I call this meeting to order. Welcome to meeting number 66 of the House of Commons Standing Committee on Natural Resources. Pursuant to Standing Order 1082, the committee is meeting on the Canadian pulp and paper industry. Today's meeting is taking place in hybrid format. All of the members are online. Good to see you. You know the drill, so I'm not going to go into the details. Welcome to our guests who are here in person today. We have, for witnesses, representatives from Industry Canada, Mark Sean, if I get anybody's names wrong, correct me when you take the microphone, and Denise Dojak. First of all, Senior Assistant Deputy Minister, Strategy and Innovation Policy Sector, and second, Director, Investment Review Division. Natural Resources, Greg Smith, Director, Economic Analysis Division, Trade, Economics and Industry Branch, Canadian Forest Service, and then Public Safety Canada, Richard Bilodeau, Director General. And so we're going to go with two of the department's 5-minute opening statements. I use a handy card system. I'll give you the yellow card, 30 seconds left, red card, wrap it up, but don't stop mid-sentence. And then we'll get into our rounds of questions, which starts off with 6 minutes for each, and then shorter ones after that. So let's go to our Industry Canada representatives first, and we'll get right into it today. You'll have 5 minutes on the clock.
Thank you, Mr. Chair. Mr. Chair, members of the committee, good afternoon. My name is Mark Sean, and I have recently been named the Deputy Director of Investments, where I'm responsible for assisting the Director of Investments and advising the Minister of Innovation, Science and Industry on reviews conducted under the Investment Canada Act, or the ICA. I'm accompanied by Dinesh Dojak, Director of Operations of the Investment Review Division, or IRD. Amongst other things, the IRD is responsible for administering the ICA on behalf of the Government of Canada. Thank you for the invitation to participate in the committee's study of the Canadian pulp and paper industry. Je suis conscient que ce n'est pas tout le monde qui connaît le fonctionnement de la...
I'm aware that it's not everyone that knows the law in great detail in forest management. I'll give you an overview. It plays an important role in the economy of Canada. New technology is introduced and practices will improve productivity of these Canadian enterprises. The law allows for the acquisition of properties by non-Canadian owners or proprietors. And so far, there's a net benefit, economically speaking, for Canada. Canada Investment Act, of course, allows an overview of all the investments for security reasons.
Seeking directly acquire control of a Canadian business valued at or above the relevant net benefit threshold must submit an application for review. The Minister carefully considers each transaction subject to net benefit review on its own merit and approves foreign investments only if they are likely to be of net benefit to Canada, according to the factors set out in the ICA. It is worth noting that as a result of Canada's international commitments, indirect acquisitions by World Trade Organization investors, that is to say where the Canadian business is acquired as the result of an acquisition of a corporation incorporated outside of Canada, are not reviewable under net benefit provisions of the ICA. The ICA also provides for a review of investments that may be injurious to Canada's national security. All foreign investments are subject to the national security review process set out in the ICA regardless of value. The national security provisions set out a multi-step process that involves numerous departments and agencies that have responsibility for protecting Canada's national security. Through this process, the government is able to consider all the relevant facts and make a determination of whether an investment would be injurious to national security. Rest assured, the government does not put Canada's national security at risk for the sake of foreign investment. It should be noted here that the ICA is just one tool amongst many to ensure the protection of Canada's national security, including sector-specific tools. National security reviews under the ICA are multi-step processes with strict deadlines and different legal thresholds for action at each step. From day one, national security experts, principally the Department of Public Safety and Canada Security and Intelligence Agencies, are fully engaged. To ensure all security dimensions are considered, it also involves departments and agencies with specific expertise in the sector or industry in question, such as Natural Resources Canada. If the transaction does not meet the legal threshold to extend the review, meaning the Minister finds it is not to be injurious to Canada's national security, then the national security review process ends. As
is the case for all foreign investments, each investment has been reviewed in detail. We're using the departments that are involved, including the Ministry for National Security and the Government of Canada as a whole. As to the results of the Paper Excellence Review, if there are no problems, it is in keeping with the National Security Act. On paper excellence, these investments in Canada appear in the papers. Investments in Canada may limit on some of the details. We can stress that each investment is examined as to its motives and the net benefit principle.
Their national security interests. The government does not hesitate to take decisive action, and our assessment of risk keeps pace with evolving economic and geopolitical circumstances. Thank you, Mr. Chair, and I'm happy to answer the questions the members may have.
Perfect, thank you. And we'll now move to natural resources to Mr. Smith, and you'll have 5 minutes for your opening statement. Over to you.
Wonderful. Thank you very much, Mr. Chair. Good morning, committee members. I'd like to begin by recognizing that we are on the ancestral land of the Algonquin and Anishinaabe people. I'm Greg Smith. I'm the Director of the Economic Analysis Division of Natural Resources Canada's Canadian Forest Service. I'm here representing the trade, economics, and industry branch in the Canadian Forest Service, and thank you for inviting me. Canada is a steward of a vast forest resource. Our 367 million hectares represent 9% of the world's forests. From harvesting trees to producing everyday essential goods, the forest sector is a key pillar of the Canadian economy. Contributing approximately $33 billion to GDP, it directly employs over 200,000 people, including 11,000 Indigenous people. The forest sector is particularly important in many rural, remote, and Indigenous communities, where it is often a primary source of jobs and income. Forests also sustain over 1,400 Indigenous businesses and joint ventures across the country. Nearly 90% of Canada's forests are owned by provincial and territorial governments who have jurisdiction over the management of these forests. Canada's forest laws are among the strictest in the world. The provinces and territories develop and enforce laws and policies that protect our forests and ensure that sustainable forest management practices are followed across the country. They manage forests for multiple public policy objectives, including conservation, water and soil quality, biodiversity, socioeconomic benefits, and climate resilience. In fact, nearly 160 million hectares, or about 70% of our managed forests, are third-party certified. So these certifications complement Canada's comprehensive and rigorous forest management laws and regulations and provide assurance that a forest company is operating legally, sustainably, and in compliance with world-recognized standards. A certification is issued only after a thorough review by a third-party auditor determines that, among other things, the long-term harvests are sustainable, and there is no unauthorized or illegal logging, wildlife habitat is preserved, and soil quality is maintained. Canada harvests over 700,000 hectares of forest area each year, about 0.2% of our total forest area. In comparison, and we worked on this comparison for a while, that's roughly the size of a smartphone on a ping pong table. The pulp and paper industry is a key segment in Canada's forest sector supply chain, consuming residual material from sawmills to create pulp and paper products. Across Canada, there are over 80 operating pulp and paper mills and facilities, and with Quebec housing the lion's share of these facilities with about 43%. And Quebec has also been a leader in developing its bioeconomy by exploring innovative uses of forest biomass and supporting the development of higher value-added products from harvested wood. Part of managing a forest sustainably means adjusting annual harvest levels over time to account for changes in the forest, such as disturbances from forest pests and wildland fire. Over the last decade, these natural disturbances have had a significant impact on sustainable harvest levels and consequently on the wood fiber available to make forest products. This challenge has urged Canada's forest industry to increase the value it receives from what is harvested. Obtaining more value for every cubic meter harvested allows Canada to position itself as a leader in the growing global bioeconomy and enhance our economic resilience in the forest sector. At Natural Resources Canada, we work with provinces, territories, and industry stakeholders to ensure the Canadian forest sector has the support it needs to take advantage of the opportunities presented by the growing bioeconomy and to continue to support workers and communities across the country. One of our objectives is to develop strategies to help strengthen competitiveness and overall health of Canada's forest sector, and to support the future livelihoods of workers and their communities in a transition to a low-carbon global economy. Budget 2023 proposed to provide $368 million over 3 years, starting in 2023-2024, to renew and update forest sector support, including for research and development, Indigenous and international leadership, and data. Thank you for inviting me. I'd be happy to answer any questions about the forest sector and its management in Canada. Thank you.
Well, everybody's tight with their opening comments this morning. That's appreciated. I'd like to also welcome Michael Cram, Mr. Michael Cram, and Mr. Dan Albus to our committee this morning, along with all of the regular members. We're going to get right into our first rounds of questions, which are 6 minutes each. And first up, I have joining us online, Mr. Ted Falk. So, Mr. Falk, it's over to you for your first 6 minute opening round.
Thank you, Mr. Chair, and thank you to our witnesses for attending committee this morning. Appreciate that very much, and sorry I'm not there in person. I'd like to start off by asking if they could just briefly identify, for the record, what is the process for a foreign entity to buy a natural resource company in Canada?
I'm happy to start. So, as noted, it would depend a little on the nature of the transaction. So, as noted, if the transaction meets the threshold for a notifiable investment into Canada from a foreign buyer, that would require notification to the Investment Review Division, and then it would depend a little on the nature of the investment. As I noted, indirect investments via the acquisition of a company that has Canadian assets but is not domiciled in Canada is considered an indirect transaction, and under our trade agreements under the WTO, those are not reviewable on a net benefit basis. They are, however, reviewable under a national security basis. And so if the transaction of a natural resource asset was made by a foreign buyer, was notifiable, and was a direct transaction, that would proceed to both a net benefit review and then also a national security review. In the case where it was not a direct transaction, it would only proceed to a national security review process. The national security review process is subject to all foreign investments that are made into Canada, and the process is undertaken in consultation with the Minister of Public Safety and Canada's national security and intelligence agencies. And each stage of the process is engaged. A national security review can last 200 days or longer with the consent of the minister and the investor. And so just by example, in 21-22, there were 1,255 investment filings, as well as additional investments not subject to filing requirements that were reviewed under that process. I'm happy to get into more detail if the member is interested, but broadly speaking, that is the nature of how a transaction would be assessed.
Okay. Thank you. I guess in particular with Paper Excellence, which is what we're studying here this morning, did you do a review on that, on some of their purchases?
So Paper Excellence transactions have getting my notes. There have been a number of investments by Paper Excellence in Canada over the past few years. These include the acquisition of Catalyst in 2019, of Domtar in 2021, and then of Resolute in 2023. While none of the Paper Excellence investments have qualified for net benefit review, all of its investments in Canada were reviewed under the national security provisions of the ICA.
Okay, and the reason that you say they didn't qualify for the net benefit is because they were purchased by a Canadian entity, as far as a registered Canadian corporation?
No, they're an indirect transaction. So the to kind of make it just for ease, the primary transaction. So essentially, when a Canadian asset is first acquired, essentially. So let's imagine we have a Canadian company that has Canadian assets. The first time a foreign transaction occurs, that is subject to national to net benefit review. But if that company and that transaction proceeds, and then there's a subsequent acquisition down the road. So Company A, Canadian with Canadian forest pulp and paper assets, gets bought by American Company B. American Company B then goes on to buy additional Canadian assets. A third transaction happens with an American company that buys company B of America. That's not subject to net benefit because essentially the Canadian transaction has already been reviewed under the net benefit, which was the very first transaction for the Canadian assets in question. In this particular case of Paper Excellence, it was an indirect transaction. So Paper Excellence bought Resolute, and Resolute had already bought the Canadian assets that had been a transaction that had been subsequently previously considered.
Okay, and when you've looked at the ownership structure of Paper Excellence, have you been able to determine the beneficial owners?
So one of the mandatory forms or fields under the mandatory filings when you submit for investment review is to provide us with the ultimate controller or controller in fact for the asset. So it is required under our processes that we understand the beneficial owner of the firm.
Okay, and so the answer to that would be you. In the case of Paper Excellence, you've been able to determine who the beneficial owner would be.
That's correct.
And who would that be?
The natural person. Dinesh, do you want to weigh in?
Yep. So in this instance, the beneficial owner is Mr. Jackson Wijaya Limitara.
Okay, and would he own 100%, or does he have shareholders?
So unfortunately, the details of the ownership structure are subject to the confidentiality provisions of the Investment Canada Act. So while we are provided with detailed information about the ownership structure all the way through the various holding companies and relative equity shares, in order for the government to be able to continue to get this information from investors, we promise investors that we will not disclose this information without their consent. And so the details of that ownership structure are subject to the confidentiality provisions of the Investment Canada Act.
And we're out of time on this round, or on this first question. We're going to go next to Mr. Blois, who will have 6 minutes on his clock. The floor is yours, Mr. Blois.
Thank you very much, Mr. Chair. I'll start with my comments or my questions to Mr. Shan. Mr. Shan, this was a good exercise for me to go actually look through the ICA in detail and see the different thresholds. Can you help describe to me what a WTO investment is? Because, of course, there's delineation under the Act about what is WTO investment versus what isn't. But just quickly, for the benefit of this committee, what is a WTO investment versus not?
I'll turn to my colleague for that.
So a WTO investment is an investment where the ultimate controller is based out of a country that is a WTO member.
And how many WTO members are there around the world? I would presume most of the world would be covered by that provision, would it not?
Yes, most of the world is covered by that provision.
Okay. And I obviously there's different thresholds in terms of the actual monetary amount in which something is triggered. Mr. Shan had explained that there's an economic benefits analysis, and then there's also a national security analysis. My two questions are, on the economic benefit analysis, is there any ability, if there's a series of transactions that fall under the threshold but are correlated together, is there any recourse for the regulating agency in the case where, let's say, I think, for example, there's a $1.3 billion threshold in one case, but what if there was a series of investments that were a series of companies that were related, but under that? Is there any recourse for regulators in those senses?
So I'm happy to start, and then I'll turn to my colleague. So it's worth understanding the nature of the transaction. So for private sector WTO investors, as you noted, it's $1.14 billion in enterprise value that is the determinant threshold, and for state-owned WTO investors, it's $454 million. And then for private sector trade agreement investors outside of that, it's $1.71 billion in enterprise value. So I think in many of these cases, if it was a series of related transactions, it ultimately would be determinant on us and the investor to actually understand what is the actual nature of the investment, and it's worth noting that all of those are reviewable under the national security provisions, and insofar as potentially there's a cumulative series of near-term transactions, we would need to be able to assess and understand the degree to which those related transactions were singular potentially in nature.
So is there a threshold, Mr. Shan, for national security in the sense that you mentioned, of course, all of these types of investments can be reviewed under the national security lens, but is there a threshold economically in terms of enterprise value similar to the economic analysis that's in place?
In fact, no, on purpose. The intention is to allow the ICA to be able to contemplate the national security considerations of all transactions, regardless of value, because some of those transactions, while potentially not necessarily high in value, may actually have very significant national security considerations, which is why there was 1,255 such reviews in our 21-22 year, because there's just a number of transactions that are worthy of our consideration.
And so that's, I looked at obviously any agreement. I apologize, Mr. Chair. I'm getting a lot of feedback as I ask questions, but my question is around, of course, we have a number of economic agreements, trade agreements. And so, Mr. Shan, what you're saying to this committee is that there's always a lens on national security, notwithstanding there might not be an economic benefit because we're trying to drive trade relationships to not slow down economic considerations between countries that the government of Canada has deemed important trade partners. But notwithstanding that, there's always a delineation of where those companies, those relationships, and how that can tie back to our national security.
Correct, and it's worth noting that all of those investment transactions are subject to national security, recognizing that there's a multi-stage process that can play out that could last as much as 200 days. But it's often thought that there's either been or not been a national security review, when in fact there has always been a national security review. It's just that some national security reviews are slightly longer in nature.
Mr. Shan, you mentioned factors economically. In as quick as amount of time as you can you mention what those factors are from an economic side, but also more national security? I mean, part of the concerns that are being raised and is, of course, the geopolitics has changed a lot in the last year and a half around national security with the war in Ukraine and different actors. Can you speak to what factors might go into playing in a national security context review? Because obviously that happens on every single investment. Are those factors listed, and how do we go about making that assessment?
I'll turn to my colleague for that.
So you've asked two questions, one about the factors on net benefit review and one about the factors on national security. So I'm going to focus on those separately.
I'm more interested on national security, please.
You'd rather me focus on national security. All right. So we have the national security guidelines. These were recently updated in 2021 to set out a series of factors that we would consider. They're quite long, so I'm going to provide some examples of factors that we would consider in a national security review. So impact on Canada's military supply chains, potential for espionage, impact on critical minerals, potentially the investments in sensitive technology sectors, physical location of an asset. So is an asset located immediately adjacent to a Canadian military base or other sensitive site? I could go into more detail depending on your interest, but they are set out in the National Security Guidelines, which were updated in 2021.
I would love to, but I'm out of time. And thank you, Mr. Chair, and thank you to the witnesses.
Perfect timing, and we're going to now go to Monsieur Simard, who will have 6 minutes.
Merci beaucoup, Jean.
Thank you very much, Mr. Shan. I'm going to focus a little bit on the ownership structure of Paper Excellence. I know that you gave us some details on indirect investment and what, of course, will trigger a national security review. I think on the various transactions, there was an analysis done for national security, correct? Can you offer us any documentation of the results of that analysis? The Council of these reviews is bound by confidentiality. No, okay, I have an answer from that. Thank you. Now, Public Accounts Committee, looking at the modernization of Pfizer, managed to obtain this information. I think it's important to have this information. And in the last answer that you provided, or it might have been your colleague, in response to a question from one of our colleagues, Mr. Wijaya was the beneficial owner, And a further analysis was conducted to establish the ownership structure in more detail. The link that we're trying to see is the link between Mr. Ajaya and another firm. Well, as my colleague did say correctly, the ownership structure of this is subject to confidentiality clauses in the agreement. My question is quite simple. Do you have the results of an analysis which, yes or no, don't give me the answer if it's confidential, but that does establish a link between Mr. Wijaya and Agent Pulp and Paper? I asked the question, well, the question was asked earlier, and the answer was we can't provide that because it's under confidential lock. Well, I can tell you that the beneficial owner of Paper Excellence is Mr. Wijaya. But do you have any information that would inform you in the ownership structure that Mr. Wijaya is financed by Agent Pulp and Paper? Well, in applying in the Investment Canada, the ICA, the beneficial owner is identified, and that happens to be Mr. Wijaya. Right. I don't want to go around and round here, but Mr. Jojak responded to my colleague that there was an analysis conducted to see in greater detail what was the ownership structure. And you should, of course, have learned if or not Mr. Wijaya has any link with Mr. Wijaya and Agent Pulp and Paper. Now, you did conduct the analysis. You're not allowed to give us the results, but the analysis was conducted, was it not?
Part of an application, we receive information on an ownership structure as pro form for all investments. And so we're given the ultimate controller. And then it is very common that investments are held through a series of holding companies, subsidiaries, and so we get that information. Similarly, when we get the ultimate controller, if there are reasons to believe there would be influence, we clarify other places. So for example, we consider something to be, generally speaking, controlled by somebody if they have a third of the equity in the company.
Ma question va être plus simple que...
I'll simplify my question. You did conduct a security analysis, and obviously somebody should have asked, is there a link between Mr. Wijaya and Agent Pulp and Paper? Now, I understand that you may not divulge this information, but I'm sure somebody must have thought to examine if there were a link between Mr. Wijaya and Agent Pulp and Paper. Now, you can't share that information with us. Fine. But the minister must have this information because he's not going to make a major decision without all the information. So, was that issue examined?
The existence of a particular document, what I can say is that in every transaction, we understand the ownership structure as well as the relative financial positions of the companies that are making investments through the Investment Canada Act. I think it would be speculation for us to be able to comment on whether or not an existence of a particular affirmation document or not exists in the case of this. And I think it's important just to note that all of that is subject to the confidentiality.
Je comprends.
Yes, I understand that it's very, very difficult and delicate to answer this question. In November last, Mr. Champagne announced that he had conducted an analysis of certain firms engaged at levels close to the threshold, and probably indirect, a synonym, Zinji Mining, and he requested that they would cease participating in this because of critical minerals. That's an indirect investment, correct?
We'll have to leave that one. We're half a minute over, so Monsieur Simard will have another round he can come back to. We're going to go now to Mr. Angus. The floor is yours for 6 minutes.
Thank you very much, Chair. I only have 6 minutes, and I certainly don't want to be rude, so I'm not really interested in theoreticals. I'm only interested in direct answers on what we're looking at. When I look at the Investment Canada webpage, it's wonderful. It reassures Canadians that you guys are there to review significant investments in Canada by non-Canadians. But when we're looking at control of 22 million hectares of Canadian forests, apparently by an individual, Jackson Wijaya, I'm to understand from what you're saying was that you did not do that review because of the WTO. Is that correct?
A net benefit review on this transaction was not conducted.
Yes. So would you at least tell us, is the WTO member that you're protecting based in China?
The transaction, so the WTO relates to the nature of the firm, and in this particular case...
So is the firm based in China?
Paper Excellence Group, which is the holding company, is a Dutch firm. It's a Dutch holding company.
Oh, it's a Dutch firm. But you have the documents on who's the ultimate controller. So did you not check? Do you know who the ultimate controller is?
Yes.
Is it in China?
The ultimate controller is Mr. Jackson Wijaya.
Oh, I see. Okay. What's interesting, because when Premier McNeil of Nova Scotia went to deal about Northern Pulp and Paper, he flew to the CNR Moss offices in Shanghai, because that's where the Premier needed to meet to find out about Paper Excellence, because they worked for CNR Moss. So did you confirm that CNR Moss in Shanghai office is the ultimate controller of Paper Excellence? Did you do that review?
I can confirm that investments under the Investment Canada Act require us to understand the beneficial owner and the ultimate controller of the firm.
Okay, so will you tell us, is the ultimate controller CNR Moss?
The ultimate controller is Mr. Jackson Wijaya Limintara.
Oh, I see. Okay, because I have a briefing note here from the Nova Scotia government that says, that tells me that what you're telling me is not true. The Nova Scotia government internal document says that Paper Excellence is ultimately controlled by Asia Pulp and Paper, an integrated pulp and paper company division of CNR Moss. So are you saying that Asia Pulp and Paper is not in control of Paper Excellence and then up through that to CNR Moss? Will you turn over the filings that they do, their mandatory regulatory filings, so we know what you know?
I'm not in a position to disclose that information. It is subject to the confidentiality provisions of the Investment Canada Act.
Okay. If our committee requested it firmly, I think this would be in the Canadian interest. But I'll continue. I have an email addressed to jackson.wijaya@Asia Pulp and Paper regarding theft of Canadian intellectual property. Did you do any investigation into whether Asia Pulp and Paper is involved with Jackson Wijaya and allegations of theft of Canadian IP?
I can simply confirm that a national security review of this transaction was conducted.
And you gave him thumbs up. I guess I'm having a hard time believing you, because we have evidence, including the emails, that Jackson Wijaya works for Asia Pulp and Paper. We have that the Premier of Nova Scotia flew to CNR Moss, and yet you come here and tell me, oh, no, it's run out of Netherlands by an individual. So I'm going to ask more about Asia Pulp and Paper and whether you did your job, because it is about the interests of the Canadian people. If Jackson Wijaya works for Asia Pulp and Paper, we're dealing with a company that has serious international allegations of environmental devastation. They lost their FSC certification. There's been international environmental campaigns against CNR Moss. There's been default on loans. And now we have allegations of theft of Canadian IP that was bootlegged for Chinese competitors. Did you guys look at any of this in your security review? Will you confirm yes or no?
I can simply confirm that a national security review of this transaction was conducted under the factors that are considered in our national security guidelines.
Okay. So you gave thumbs up. So did you look into Asia Pulp and Paper, or did you look into this guy, Jackson Wijaya?
I can simply confirm that a national security review of this transaction was conducted under the Act.
That's it. Okay. So we've been told by whistleblowers out of Shanghai that assuming control of 22 million hectares of Canadian forest is a fiber grab for Sinar Mas Asia Pulp and Paper. Could you explain how us turning that over to a series of shell companies that may be Asia Pulp and Paper, where Mr. Jackson Wajea may work, that maybe Sinar Mas, where the Premier of Nova Scotia had to fly to meet, that it's a net benefit to Canadians? That Canadian security economically, regionally, and down to the community level is not being impacted. Did you look into whether this is a fiber grab by China to take control of Canadian forests?
I would confirm that a review was conducted on this transaction, which involved the responsible government departments and agencies, including Canada's Security and Intelligence Community, led by Public Safety Canada, the Department of Innovation, Science and Economic Development, and the Department of Natural Resources. As part of the review process, Paper Excellence provided representations to Canada, including meaningful commitments to maintain Canadian representation on Resolute's board of directors and senior management team.
But you will not tell us whether or not Jackson Wajea, you bothered to even look into whether Jackson Wajea works for Asia Pulp and Paper and has an office at Sinar Mas in Shanghai. Will you say whether or not you actually looked into that? Because if you didn't, that's serious negligence, and it's putting Canadian jobs, communities, and our environment at risk. If you didn't do that, what do we tell Canadian people that they should trust?
I'll say we're out of time, but I'll give you the opportunity for a brief response, and then we're going to move into our next round.
Mr. Chair, I would just note that obviously national security reviews are extraordinarily important, and we take them very seriously, and that obviously national security considerations are extraordinarily sensitive, which is why I'm not in a position to be able to reveal the specific details of the national security considerations in this transaction.
Thank you. We're now going to go to our second round, and this round starts with 5 minutes, and Mr. Albus, you have the floor first.
Thank you, Mr. Chair, and it's great to see a British Columbia in charge here. Thank you to the witnesses for what you do for Canadians. I'd like just to follow up on MP Angus's request. Is there a way that you can bring forward any kind of document that would refute the documents that show Nova Scotia believes that there's a different controller, ultimate controller of these companies?
I'm not in a position to provide documentation related to the ownership structure of the company because it's subject to the confidentiality provisions of the Act.
Okay, well, I'm not ultimately a member of this committee, so I'll let the regular members decide what to do in the face of that answer. Now, you use the term meaningful commitments. So, you know, my only experience where I've had a very, very bad experience of the ICA is with Ong Bong, the purchase of Retirement Concepts in British Columbia that ultimately saw the purchase of that company, and then a number of provisions were promised by the government in the House of Commons saying that Ong Bong would be held to high standards, and then ultimately it was left to the Minister of Health in British Columbia to basically push that company to make sure that seniors were getting basic services that were necessary under the law. So when you say meaningful commitments, can you maybe tell me, are those actual locked-in-stone commitments, or are they just commitments they've made to the government, and now you're using that as I should say the government's using that as a fig leaf? Maybe you could just go into a little, so we know exactly what kind of commitments have been made in order to have the ICA approve this deal.
So the commitments are made by the investor as a part of their commitment in allowing the government to proceed with the investment. It includes ensuring no less than 2/3 of the members of Resolute Canada's board of directors are Canadian. It includes ensuring no less than 3/4 of Resolute Canada's senior managers are Canadian. It includes continuing to produce craft pulp at Resolute Canada's facility in Saint-Félicien, Quebec, and making an annual maintenance expenditures at a level consistent with Resolute Canada's past practice. It includes giving full and due consideration to investing in the conversion of Resolute Canada's facility in Gatineau, subject to market conditions, as well as availability of skilled labor, fiber commitments, and the Quebec government's support. It includes maintaining existing Canadian patents and patent applications owned by Resolute Canada. It includes adhering to Canadian employment and environmental laws consistent with Resolute Canada's past practice. It includes learning from Resolute Canada's environmental values, including responsible environmental stewardship, sustainable forest management, and implementing environmental management systems across Resolute Canada's facilities. and implementing leadership and human resource practices to create an inclusive workplace at Resolute Canada.
So the question is then, first of all, those are meaningful commitments for the company to the government, or are these meaningful commitments for the government to ensure that the company follows through on?
I'm not sure I understand the distinction.
Well, the distinction is if I make a commitment to you to be here on time for work tomorrow, but the thing is you're not here to pay attention to that, and I don't show up, that's the difference.
So I think we've negotiated commitments from the investor that we believe ensure the continued role of the firm in Canada and its continued meaningful participation in the industry.
Whose job is it in your department to follow up to make sure these commitments are being done?
Dinesh, do you want to speak to that?
So as part of my team, we have a compliance and monitoring function, which will include receiving annual reports depending on the nature of the commitments to ensure that companies are compliant. When we review annual reports, we make sure they're compliant, but we also consider alternative factors. So, for example, as a result of COVID-19, there were a number of facilities that had commitments around expanding facilities, HR commitments, personnel commitments that were not able to make them, and so we allowed exemptions for that.
Okay, my time is short. How many full-time equivalents are dedicated towards making sure that they're reviewing and ensuring compliance of these meaningful commitments?
I think we can come back to you on the number of full-time equivalents within the Investment Review Division.
Yeah, if Mr. Chair, if the committee could ask for that information to be in. And how much time do I have? 30 seconds. So I just, as a concerned British Columbian, I would just like to make the comment that, Domtar effectively, in my opinion, and again, it's people can question whether it's an informed one, I'll leave it to them, has the ability to set effectively, they have monopsony power and can set the price for things like hog fuel, which is a critically important area and can change the course of an industry and especially the smaller ones. So I just wanted to say, Mr. Chair, this is important, and it's not just the national security, it's also the competitive aspects of our marketplaces.
Thank you, Mr. Albus. We're going to go next online, I believe, online to Mr. Sabera, and the floor is yours for 5 minutes.
Good morning, Chair, and good morning, everyone. Happy Friday to you. This has been a very important conversation, a very insightful one. I wanted to ask first to Mr. Dinesh, when you're looking at, use the word factors, when you're looking at a transaction, an M&A transaction, an acquisition, and you've determined that the purchaser is attached to a sovereign entity, that the purchaser is not what I would call a non-market entity, is attached to a non-market entity, so a sovereign wealth fund, a government-backed organization. How much weight do you put in that factor in terms of doing the analysis? Because I think today, you look around the world, whether a transaction's $30 million or whether it's $3 billion, the IP attached to the transaction, the government, the state actor who's being the acquirer, and stuff like that, to me raises a lot of questions, particularly where we are in the world. Can you talk about that for a second, please?
So yes, ownership and whether or not something is allied with is a state actor or potentially has been influenced by a state actor is a factor that is considered in a national security review. Reviews are holistic, and so there's no definitive weighting. It depends on the nature of the transaction, the amount of equity that the particular investor has, as well as their overall influence on the company. So do they have board seats, things like that. It would be difficult for me to say, there's no sort of percentage weighting that a particular factor is given. It is a holistic review that is conducted in conjunction with Canada's security and intelligence partners, as well as relevant departments and agencies. So in the case of a natural resource transaction, that would be Natural Resources Canada. And together as a community, we assess the transaction and all the relevant factors, including whether or not an entity would be state-owned or state-influenced.
Okay, because there is this term that's used, like the golden share. An entity, a government may own 5% of a company, effectively blocking the company from being taken over, and it's used quite effectively around the world. So in this case, a company A based in say this situation, China, could have a 5% or a 10% or a 3% equity stake in company B based in another country, and that company can then purchase assets abroad, but de facto, even though company A only owns a small percentage, it has much influence on company B. And that to me is, I think about that. That to me, that scenario is there. But I do want to ask a second follow-up question. The Investment Canada Act, there is a bill going through Parliament. How different would the analysis be today, or ex ante, I guess, ex ante, I think it is, going forward? Going forward, how different would the analysis be going forward than when under the existing or the old Investment Canada Act and the analysis that's done there in this type of transaction?
Thanks so much. I'll address two aspects of your question. First, just maybe to touch on your previous question, it is worth noting that influence, ultimate control, control in fact, and meaningful control are all factors that are extraordinarily important to the understanding of a given investment and are obviously factors that are considered within the national security provisions of the Act. With respect to C-34, which continues to work through the parliamentary process in terms of modernizing and updating the Investment Canada Act, it does make fundamental improvements to the overall functioning of the Act. That said, many of the kind of core aspects, notably the continued usage of a national security review for all investments and a net benefit review of those that meet the threshold is an important part. Some of the improvements, though, are, for instance, things like the capacity for us to have binding undertakings under the national security provisions of the Act. Right now, something that we put in through the order-making process and other aspects, but it will actually allow for those in a more direct way. It will also allow for us to be able to have the maintenance of things like an ongoing set of sensitive technologies and sensitive industries that will allow us to ensure that we've been very clear about the types of investments that will need pre-clearance as a function of the Act.
We're out of time on this.
Are we out of time?
So, yeah, we're out of time. It goes fast, and it's going to go even faster now because we're going to Mr. Simard, who has 2.5 minutes.
Oui, merci.
Thank you once again, Chair. You answered a question to one of my colleagues as to meaningful commitments. In Saint-Félicien, for example, and Gatineau, the maintenance of Canadian patents. How can you assure that? How can you assure us of that? Is that not part of the confidential information? Well, as my colleague stated, the factor of these Canadian companies is overviewed, is monitored by way of annual reports, and we continue to ensure that these meaningful commitments are being respected. And you can provide us some documentation to support that. You can provide us some documents about the meaningful commitments that these companies have taken towards Canadian government.
Much of this is subject to the confidentiality provisions of the Act. However, the company has agreed to public commitments.
Attendez.
One moment, please. If it's confidential, you wouldn't tell us that they committed to maintain the operations of both of these pulp mills. So it's no longer confidential. You're telling us this in public hearing.
This is subject to the confidentiality provisions of the Act. We do have the permission of the firm to be able to reveal the commitments in this particular instance, and they are as I documented, and I'm happy to ensure that the committee has those.
Est-ce que vous avez reçu la permission?
Have you received the consent of the corporation to provide some information on the structural ownership?
Structure of the firm.
Mais là, ça vous pouvez répondre par où?
but you can say yes or no. The corporation allowed us to provide information on its corporate structure or not.
Reveal any further information related to the ownership structure
OK.
of the firm.
Ce qu'on cherche à tout le monde, et vous pouvez répondre.
Okay, well, at least you can answer the following question. Now, what I want to know is if there's a link between Wijaya and Sinar Mas. Does your department have that information?
Ownership structure is one of the fundamental fields that's required under the Investment Canada Act, and that was provided as part of this overall application.
Thank you. We're out of time on that one. Now to Mr. Angus for his 2.5 minutes.
Thank you so much. One of the reasons this issue has become such a concern is we've had whistleblowers from Asia Pulp and Paper Shanghai who are saying this expansion in Canada is a, quote, fiber grab. In fact, one official said it's a fiber grab. They want to keep the perception that paper excellence is an asset of Canada, for Canada, and by Canada. But in reality, it is a feeder for the Chinese machine. And I ask that because in the Resolute review, Paper Excellence was obliged to divest itself of the Thunder Bay mill operation, but the wood rights, the forestry rights, were retained by Resolute, which is retained by Paper Excellence and possibly Asia Pulp and Paper. You can't run a mill without trees. Why would you let those trees be handed over to Asia Pulp and Paper through Paper Excellence?
I believe the member is referring to two different aspects of review of transactions related to this industry. The first is specific to the National Security Review. The other is the review of the Competition Bureau with respect to transactions as to whether or not this creates a significant lessening of competition.
Okay, I guess I asked the question because I spoke with a forester for Thunder Bay who said allowing Paper Excellence Resolute to control that forestry license without having to maintain the jobs at the mill is a great game of trickery. You said the company has allowed you to make some explanations of what they're up to. Would you ask the company if they would explain to us, what are they going to do with that damn wood fiber? Is that going to China? Why is it not going to a mill in Thunder Bay where we have hundreds of workers who are dependent on those forests? Why would the Canadian government allow Paper Excellence to walk away with those forestry rights? How do I explain that to workers? How do I explain that to communities that you guys are doing your job?
As I noted, Mr. Chair, this transaction was subject to the Investment Canada Act for the purposes of the National Security Review and was not subject to a net benefit assessment as a function of the fact that it was an indirect acquisition. And so from a National Security Review perspective, this transaction was deemed to be able to proceed following the meaningful commitments made by the firm.
So it is a fiber grab, and you didn't have a problem with that?
Mr. Chair, I'm not in a position to respond to that question.
Thank you, and we're out of time. We have two 5-minute rounds left in this hour, so we'll go first of all to Mr. Dreeshen online, and then Mr. Blah will finish us off. And so that's, for the witnesses, what you can expect for the remainder of this morning. So, Mr. Dreeshen, over to you for your 5 minutes, please.
Well, thank you very much, Mr. Chair. And I'd like to talk more with Natural Resources and the witness and some of the discussions and points that he had mentioned. You'd said that Canada has 9% of the world's forests, and of course, you had also mentioned in your testimony a discussion about climate resilience and third-party certification. So I'm wondering if you could expand on what that is all about, and then I'll ask some questions about lease processes and how companies are involved with forests as far as leases are concerned.
Thank you very much for the question. So, as I noted, Canada has the largest area of forests in the world that are where practices are third-party independently certified. They may be certified by one or more third-party standards, including the Canadian Standards Association, Sustainable Forestry Initiative, and the Forest Stewardship Council. Approximately 158 million hectares, or as I mentioned, about 70% of Canada's managed crown forest are certified at one of these under one of these certifications. And what these certifications do is they provide added assurance that a forest company is operating legally and complying with internationally accepted standards for sustainable forest management. So all companies However, of course, all companies operating in Canada must comply with the laws and regulations with respect to the forest sector writ large. And this supports Canada's reputation, of course, as being a reliable source of legally and sustainably produced forests.
Thank you. And you mentioned that the provinces, of course, manage forestry lands, and I'm wondering if you can explain what the role NRCan plays in the management of land leases, and more specifically, pulp and paper, the pulp and paper industry.
Yeah, absolutely. So forests and provinces, as you mentioned, hold jurisdiction over the forest, and they're the ones that regulate the harvesting and determine which standards are set. And they delegate responsibility to private forest companies through licensing and timber supply agreements. And these are typically known as tenure agreements. And these arrangements grant a license to harvest, and they both contribute to Crown revenues for provinces, but also for the federal government via corporate income, and then assume a defined responsibility. Sorry, these companies assume a defined responsibility for their management. So there's a variety of different ways provinces go about determining who gets tenure in these instances. For the sake of time, I won't go into all of them. However, each province has their own approach in how to do that. How does NRCan, your second question was, how does Natural Resources Canada work with provinces on this? So through a variety of means. One, we have a well-established research network that works to research forest sustainability issues. We work closely with provinces and territories to ensure that information is shared on how best practices on how to update regulations and the management of Crown timber. And also we deliver a number of programs that support transformation in the sector. I could speak more at length on that. As I mentioned, there was a recent budget, but I will not for the sake of time.
No, that's fine. Thank you very much. According to Paper Excellence's page on sustainability, the company maintains a chain of custody certification, and that includes the Forest Stewardship Council certification. I think that was discussed earlier. And so I'd like to find out just what are the benefits of this FSC certification, what impact it has on Canada's pulp and paper industry, its reputation, and our sustainability.
Number of questions there. So, as you rightly noted, the FSC certification, and our understanding is that from the Resolute transaction, or the Resolute, that 100% of the lands that would be used, held by Paper Excellence would be third-party certified, and it's just likely as noted on their website, as you mentioned. The benefit of this, of course, is many. However, it does indicate internationally that these companies are operating in a sustainable way and held to a high standard, in that they're being third-party audited by these certification bodies to ensure that they are doing so. So this gives buyers and customers of these companies confidence that they are buying sustainably harvested wood and paper products from sustainably managed forests.
Thank you. And I just have 30 seconds left. How does the FSC certification compare to other sustainability certifications that are global? I mean, you must be able to compare what we do compared to what is happening in the rest of the country, the rest of the world.
Thank you very much for the question, Mr. Chair. I don't think I'd be able to provide a reliable comparison between different certifications across the world, aside from noting that, as I mentioned, Canada is a world leader in the amount of third-party certified forests that we have.
Okay, thank you.
Thank you. And for the last 5 minutes, we're going to go back to Mr. Blois online. So, Cody, over to you.
Thank you, Mr. Chair. My questions are for Mr. Shan. In June of 2022, there was changes in Order in Council to the national security review provisions under the ICA. Can you just quickly describe the essence of those changes and what those amounted to?
Yeah, I'll start and then I'll turn quickly to my colleague. I would just, one of our outcomes that we're seeking, obviously, is to ensure that we're remaining relevant to the current circumstances. And so from time to time, the minister does provide increased clarity on what it is exactly that we are aiming to achieve through the national security guidelines. And so in that respect, in 2022, as you note, we did update those to ensure that very particular sensitive areas and sectors that were likely to engender national security considerations were identified, and that those were provided.
Thank you. The guidelines specifically, are those in Order in Council, are those regulations, or is that a departmental policy?
Those right now are a function of the minister's guidance that he provides to potential investors under his powers under the Act.
because as I listened to Mr. Angus, I mean, he was asking really important questions, very critical of your work. But what I'm trying to figure out as a parliamentarian is whether or not we have to do more to actually provide the guidance. Mr. Angus was talking about, of course, some of the economic concerns about where the pulp might be going. But if that's not actually a mandate under your direction and part of what you're being directed to study, I think that's our job as parliamentarians to understand. So on the guidelines, it doesn't seem as though there's a whole lot there's a lot around supply chains in Canada on a critical mineral sense. There's a lot on national security in terms of assets. There's not a whole lot on broader economic interests, Russia being the one example where that might have changed. Is that a fair comment, that there's not a whole lot on the security review provision that relates to external exports of Canadian materials elsewhere?
So I would parse that question slightly, Mr. Chair. I would suggest there are a number of important factors that do relate to the kind of economic makeup of a sector as we think about the net benefit reviews that are conducted under the Act. With respect to the national security provisions of the Act, obviously a core consideration is whether or not something is injurious to the national security of Canadians, which does require a significant analysis of the sector, but is less specific to the potential benefits to Canadians, which would come under the net benefit review.
There's obviously a cultural threshold as part of this policy, whereas the investment or purchasing of cultural assets, there's a much lower threshold in terms of the economic analysis versus other elements. Is that something, I mean, look, ultimately, I guess that's up to the government, but is it fair to say that that is about trying to protect Canadian cultural businesses, and the lower threshold, of course, dictates that there has to be both an economic analysis above and beyond the national security element that you've indicated happens at all circumstances?
As I noted, the threshold for the World Trade for net benefit is a function of our World Trade Organization commitments and our international trade commitments, which is standard across all of our trading partners. As you noted, the acquisition of cultural assets is subject to a different threshold, which has been negotiated under our trade agreements as a function of the fact that the majority of those enterprises are usually of lower value, but understood to be important from a consideration of net benefit to Canadians.
So what I'm hearing then, Mr. Shan, is that if the government of Canada or Parliament was seeking to actually try to create a lower threshold in terms of the actual assets of industries, let's say natural resources or otherwise, that's actually a function of the trade agreements that we currently have. And those would have to be negotiations, amended negotiations of our existing trade obligations to get a lower threshold in the of making sure that that analysis happens for businesses like natural resources or otherwise.
The net benefit threshold is a function of our World Trade Organization commitments and is consistent across our trading partners. And so, yes, any shift to the net benefit threshold would need to be contemplated in the context of our commitments.
Mr. Chair, I have about 45 seconds. So just quickly, Mr. Shan, is there any exemptions? I did look at exemptions, and there was a provision around foreign bank acquisition or associated elements. Can you speak to any exemptions that exist under the ICA for filing and specifically address the foreign bank piece? I'm just curious in whatever time I have left, please, Mr. Chair.
The foreign bank piece, and I'll turn to my colleague if they'd like to supplement, is a function of the fact that those are contemplated under our colleagues within the financial sector, who obviously have a different test from a prudential and other risk perspective, and so they consider those contemplations, which is why they're exempt from this particular filing, but are obviously reviewed within the context of our overall financial institutional construct.
And that takes us to the end of our time this morning. So I'd like to thank our witnesses for joining us this morning. It's a very important conversation, and I appreciate within the constraints that you operate within what you were able to share with us today. Mr. Angus, do you have a point of order? Because next I just want to mention to members, we're going to go into closed next, and so all the members online will have to log out. There's a second link that you need to go to come back in on the closed. And so before we suspend, if it's a point of order, Mr. Angus, I'll go to you.
Thank you, Chair. Yes, I'm going to request for our committee so that we can do due diligence in reporting to Parliament from the Department of Public Safety any national security review that was conducted by their department for both the Domtar and Resolute acquisitions by Paper Excellence, and to provide the copy to our committee. For any mandatory filings under the Canada Investment Act regarding Paper Excellence acquisition of Domtar and Resolute, that supplied to the committee. For any briefing notes to the Department Minister of Public Safety related to Domtar and Resolute acquisitions by public paper excellence. For the Department of Natural Resources, any copy of briefing notes prepared for the minister related to the Domtar and/or Resolute acquisitions by paper excellence. And for the Department of Industry, any briefing notes prepared for the minister related to the Domtar and/or Resolute acquisitions by paper excellence.
Okay, thank you. We'll consider that as being put on notice, and we'll dispense with it within the allotted time periods. So thank you for that, and thanks for our witnesses. You're now excused for the day. Thanks so much for joining us. And for our members, we'll adjourn. And as I say, for those online, please log out and come back in on the second link for the closed session.
you